The Federal High Court's decision in Prime Tech and Design and Engineering Company Limited and Julius Berger against the Corporate Affairs Commission continue to spark a debate as to the applicability of Sections 18 Sub 2 to private companies who initially incorporated with two members and have decided to reduce their membership to one. While we're waiting on the decision of the appeal in that matter, today we're discussing membership of a company. This is day 5 of the 30 days Know Your Karma challenge with Beyond the Boardroom with CJ, and I am CJ. We're looking at sections 105 to 123 today. Let's go real quick. Section 105 defines a member as once a person subscribes to the memorandum of an article of association, or basically to the memorandum of the company, and the memorandum is registered, the person shall be deemed to be a member of the company. And it doesn't stop there. Every other person who agrees in writing to become a member of the company and whose name is entered in the register of the members is a member of the company. And for companies having shares, for any person that has at least one share in the company is actually a member of the company. So then let's look at who has the capacity to be a member. Anyone who has an unsound mind, who has been declared by a court or found by a court to be an undischarged bankrupt cannot be a member. And any person under the age of 18, though a member, may not be counted for the purposes of determining the legally minimum number of a company. That means if a company is supposed to have two members and it has one adult, one person over 18 and another under 18, the person under 18 will not be legally counted as a member of the company. Let's look at the rights of a member. Everyone who is a member of a company, notwithstanding anything in the provisions of the articles, actually has a right to attend any general meeting and to speak and vote at such meetings. Sections 109 talks about the register of members. Every company shall keep a register of its members, and the register of the members shall contain the name, address, details of shareholdings or class of shares, the date that the person became a member, and when the person actually ceases to become a member, that date should also be captured in the register of members. And where a company actually defaults in complying with this particular section, there's a penalty that applies. Now, the location of this register, sections 110, it says that the register of the members shall be kept at the registered office of the company. However, there's an exception to that particular rule. So, where somebody is actually working on the making of that register, it can be kept there. Also, where a company arranges with some other person for the making up of the register to be undertaken on behalf of the company by that person, it may be kept at that office of that person at which the work is done. But the register shall not be kept in case of a company registered in Nigeria in anywhere outside Nigeria. This register ought to be available upon request to members, especially for inspection purposes. However, there are times when this register can be closed, and Section 114 actually addresses that. So sometimes the register of members can be closed for purposes of audits, for the preparation of annual general meeting, whatever it is. When this register is to be closed, a publication in newspaper ought to be done. We move on to the liability of members. So it's not enough to be a member. There are liabilities on these members, and that's section 117 that says that prior to the winding up of a company, a member with shares is liable to contribute the balance, if any, unpaid as to the shares that in respect of the shares held by that person. And in the case of winding up, past members and members are liable to contribute as to the cost, as to the assets, and any expenses towards the winding up of the company. However, a past member will not be liable to contribute. That's sections 117 sub 4. And B says that a past member will not be liable to contribute if he ceased to be a member for a period of 1 year or upwards before the commencement of the winding up. Sub B says a past member is not liable to contribute unless it appears to the court that the existing members are unable to satisfy the contributions required to be made for them by them, in pursuance of this section. Sub C then goes ahead to say that in the case of a company limited by shares, no contribution is required from any member or past member exceeding the amount, if any, unpaid on the shares in respect of which he is liable to be a present or past member. And in the case of a limited by guarantee, of course, no contribution is required from any member or past member exceeding the amount undertaken to be contributed by him to the assets of the company in the event of it being wound up. We must also state that where dividends are owed to these members, such dividends cannot be used to offset this outstanding, if any. We move on to disclosure of persons with significant control. So this one is also, you should also look out for the persons with significant control regulations, I think 2022, that says that anyone who directly or indirectly owns share or interest 5% and above is actually considered a person with significant control. And sections 119 says that such person ought to be disclosed to the commission. Of course, first of all, that person, upon becoming a PSC, that's the person with significant control, ought to inform the company in writing within 7 days, and the company ought to notify the CAC within 1 month. And take note that that's for private companies, right? Because for persons with significant control, that's called persons with substantial shareholdings in public company. They actually have 14 days to notify the company, and the public company actually has 14 days to notify the CAC. And this also extends to when the person ceases to become a substantial shareholder in the public company. That is sections 121. And that's all we can take for day 5. I'll see you on day 6.